And what Jim says?
You just have to verify that you have it.
Donc, participant à l'école d'été, collègues, the participants of the summer school, your friends, your colleagues. Pleasure to welcome you to the hot topic for the 15th anniversary of the IHL Semester. C'est tout mon plaisir de vous accueillir ce soir à la conférence spéciale du 15e anniversaire de l'école d'été en droit international humanitaire. Je m'appelle Sophie Rondeau, je suis avec la Croix-Rouge canadienne. My name is Sophie Rondeau and I'm with the Canadian Red Cross. In the name of the organizing committee, we are very happy that you're joining us this evening. Au nom du comité organisateur, on est très heureux de vous voir ce soir. On a avec nous Nicolas Fuentes Forero, Jabar Fatali, Viviana Fernandez, Fanny Dagenet-Dion et Caroline Fauché. C'est l'équipe qui nous a permis d'être ici aujourd'hui. So that's the team that allow us to be here today. So I want to thank them a lot. And thank you for being here. For those of you who are online, for those of you who are in person, we would like to take a moment because we're doing this event live from the law faculty of the University of Ottawa. So we pay respect to the Algonquin people who are the traditional guardian of this land. We acknowledge that their long-standing relationship with the territory, which remains unceded, and we pay respect to all the Indigenous people in the region. It's a mix of all of those people from all nations across Canada who call now Ottawa home. We acknowledge that the traditional knowledge keepers, both the young and the old, and we honor their courageous leader, past, present, and future. For those of you who are in person, I do want to reiterate that we will have a short reception in the atrium in the back afterwards. So if you want to hang around, you're more than welcome to come and celebrate the 15th anniversary of the summer school. Before we do that, we have a very interesting presentation for us tonight that's going to trigger, I hope, a lot of discussion, and it's going to frame also a lot of issues that we tackled during the summer school. Our colleague, Jonathan Horowitz, will be talking about applying the principle of distinction to cyberspace. He will address some legal implication for civilians using digital tools in armed conflict. So the presentation will describe the phenomenon that the International Committee of the Red Cross is witnessing of civilians increasingly using digital tools in relation to situation of armed conflict. It will explore the principle of distinction applied to such situation, covering different legal issues, such as when IHL affords its protection against attack, but also under what exceptional circumstances that protection might be lost. If you've been paying attention in your classes, you can see all of the keywords popping up, everything to the distinction between civilian and combatant, direct participation in hostilities, targeting comes to a very real consequence on this specific topic. We have an amazing speaker to address this issue with us right now. I'm very honored that we can host him. Jonathan Horowitz is the legal advisor and interim deputy to the head of the legal department of the ICRC, International Committee of the Red Cross, regional delegation for the United States and Canada. He's based in Washington, D.C., where he focuses on legal issues pertaining to new and emerging technologies in armed conflict, urban warfare, and partnered operation. Jonathan received his LLM from the University of Essex in UK and has published widely on international humanitarian law and human rights law. Thank you very much for being with us. I'll be more than happy to moderate the question period. So if you have any question, we'll open the floor after the session. Unfortunately, for those of you that are online, we won't be opening the Q&A, but you can still hang on. So I'll leave the floor to you, Jonathan. Thank you.
Thank you for that introduction. Thank you to the University of Ottawa and to the Canadian Red Cross for inviting me here. I do understand it's the 15th anniversary. I've heard wonderful things about this program, so it's nice to be here in person with all of you. For me, it's the first time. Excuse me, you can tell me the way I'm able to use a mic. So I'm going to talk to you about this topic that Sophie just introduced. And it would be great if I would just be able to sort of dive into it and just talk about applying the principle of distinction to cyberspace. But what I'd like to do is to walk back a little bit, to, give you a little more background and context to how the International Committee of the Red Cross has come to think about this particular issue. The other thing that I'm going to try to do is I'm going to go old school, and I'm going to do all of this on a chalkboard, which I haven't done since I probably took a class in international humanitarian law for my LLM at the University of Essex. So please do let me know, A, if you can't hear me, if my voice is garbled. There's a good chance you won't be able to understand what I write. There's very little I can do about that, but I'll try to do my best. But do raise a hand or give a shout out to keep me on track. Okay, so we're going to be talking about, that feels nice in my hand, cyber operations in armed conflict. No big surprise there. And what I want to do within that pyramid is I want to talk to you a bit about the risks for civilians in the civilian population that we see arising out of military uses or designs for cyber capabilities, cyber tools that could be used in situations of armed conflict. I want to talk to you about the IHL considerations and implications that arise out of those potential costs, those risks, because the goal and purpose of international humanitarian law is to protect victims of armed conflicts. And then I also want to talk to you about some real-time patterns and trends that we're seeing on battlefields as they emerge, and that has everything to do with the ICRC is starting to call the civilianization of cyber activities in armed conflict. So let me start off, if I can, with the different risks that we've been able to study, largely from peacetime cyber activities, because there hasn't been a lot publicly disclosed about cyber operations that happen in the contemporary battlefield. That, of course, has changed with the situation of the international armed conflict between Ukraine and Russia, but this is a lot of work that we've done prior to that. One of the things we've been deeply concerned with is that, as you are all aware, the critical infrastructure that provides essential services to our daily lives is now heavily networked through computer systems and different digital networks. What that means is that they're now vulnerable. Those essential services are vulnerable to cyber operations and cyber attacks. I'm talking about here access to electricity, to medical and healthcare, to water treatment, to transportation, to industry, to the Internet of Things. The list goes on, because the digitalization of our everyday world is now with us and affects us in every single way. That's one big risk and concern we have. The other has to do with escalation, with conflict escalation. And this is somewhat unique to the cyber environment, where it's not always obvious who is carrying out a cyber operation, malicious cyber activity on a network. It's not always clear what their intention is, and it's not always clear whether that cyber operation is in any way linked to a situation of armed conflict. And as you know, or will know, or already have been discussing, international humanitarian law applies to and only to situations of armed conflict. So when you have a state that sees malicious activity on their network and they don't know who is doing it or for what reason, there creates an environment, the ICRC believes, for miscalculation, misunderstanding, and potentially escalation that otherwise needn't arise. The third risk is around proliferation of cyber tools and cyber capabilities. And what you mean by this is where you have a state actor, for example, that's designed a cyber capability in a very specific way, with very specific guardrails to do things like ensure that it does not spread across international borders or across systems that it wasn't meant to spread across. The concern is once it is used and is out in the quote unquote wild, there are concerns about it being reverse engineered or repurposed or mispurposed without those guardrails. And so there's great concern around what happens even with the good intentioned state that uses a certain cyber tool or capability and how it can be then remanaged, re-engineered, reused without those guardrails in situations of armed conflict. So those are three big risks that then drive the ICRC's considerations around how international humanitarian law regulates cyber operations in armed conflict. But as you may have already noticed, I've presupposed the question of whether international humanitarian law should even regulate cyber operations. There's been some debate about this. One line of debate is that international humanitarian law was crafted well before the advent of the internet. And there are other debates that contribute to this. For the ICRC, we take the very firm position that absolutely international humanitarian law regulates cyber operations in situations of armed conflict, just like any other means or methods of warfare. Where does the ICRC get off making that proposition? One, the International Court of Justice in 1996 made it very clear that international humanitarian law applies to all means and methods of warfare, including quote unquote, those in future use. Perhaps more convincingly, states, including the government of Canada, are starting to expand the consensus view that yes, international humanitarian law does apply to and regulate the use of cyber operations in situations of armed conflict. So if you can bear with me and be convinced by the position of numerous governments, as well as the ICRC, that meant that we've been allowed as an international community to move the discussion from whether international humanitarian law applies to the question of how it applies. A group of states at the UN, group of government experts dealing with responsible state behavior relating to information communications technologies, held the view, and it's been held in consensus since, with a few outlying remarks here and there by a few states, that the principles of humanity, military necessity, distinction, and proportionality all apply to cyber operations in situations of armed conflict. So we're starting to get into a little bit the weeds of how international humanitarian law applies. You can also look to unilateral government statements that have been made public about how international humanitarian law specifically applies to cyber operations, to their cyber operations. You can look to groups of legal experts that came together to write the Talon manual on this subject relating to international law broadly, not only to international humanitarian law. And the ICRC tried to make its own contribution most recently at the UN's open-ended working group on this topic by offering sort of they're supposed to be 1 to 2 pages, ended up being 2 to 3 pages, 2 to 3 page fact sheets that try to simplify what can otherwise be very contentious and complex discussions around the principles, as I mentioned, of when, one of the fact sheets is on just when IHL applies, situation of armed conflict, not to oversimplify it, but also on the principles of humanity, military necessity, distinction, and proportionality. I want to talk to you just briefly because it'll become relevant in a moment. The principle of distinction, the principle of proportionality, and something that some states are uncomfortable calling principles, but there's a general understanding that there are obligations around taking precautionary measures to avoid or minimize civilian harm. by taking all feasible precautionary measures to minimize civilian harm. So when we talk about principles of distinction, proportionality, the obligations of precautionary measures, the ICRC would regard it as a principle. We're talking about things like the principle of distinction, as you may have already discussed, tells you what persons are targetable and which ones are protected from being attacked. So on the one hand, you have civilians are protected from being attacked. Combatants may be attacked. Civilian objects may not be the object of attack. Military objectives may be the object of attack. This is the principle of distinction. To oversimplify it, if we apply it to the cyber environment, we're talking about the principle of distinction would prohibit a cyber attack that's aimed at a computer network that services an electric grid that provides energy only to civilians, right? That's the principle of distinction, pretty simple. The principle of proportionality. Well, let's think about the same electric grid, but how about that electric grid? Excuse me, let's talk about that computer network that services that electric grid. And that electric grid services both civilians, but also command and control functions of a military adversary in a situation of armed conflict, right? Here, what the principle of proportionality says is it's this balancing equation that the anticipated civilian harm must not be excessive to the anticipated direct and concrete military advantage expected. So here, that cyber operator who's thinking about planning, launching, carrying out a cyber attack against that computer network to disable the electric grid in order to provide themselves a military advantage, they have to think about whether or not the civilian harm will be excessive to the military advantage being anticipated. There are a lot of different facts to unpack, I understand that, but what I'm just showing is sort of laying out a tapestry of how it's possible to apply these principles. And the principle of precaution, the same thing. It's about designing a cyber operation, designing a cyber attack, and I'll get to why I just made that distinction in a moment. Designing a cyber attack that can avoid or minimize as much as feasible civilian harm. Now that can be done through, as I mentioned, the design of the attack. It can be done through giving advanced warning, if possible, to civilians. It can be done through choice of targets, where there's a rule that if you have two targets that provide the same a similar military advantage, you must choose the one that that is expected to produce the least civilian harm. So that's an example of how these three very important rules, principles, obligations of international humanitarian law can apply in the cyber environment. But that is not to say that it's all easy in terms of lawyers trying to figure out what the full scope of the legal obligations are of their clients who want to carry out cyber operations, or for that matter, their clients who want to think that they are protected or want to defend against cyber operations. There are several debates. The Talon Manual 2.0 is a great place. If you're not familiar with it, I'm sure we can provide you more information about it that really digs into a lot of different international legal expert views and sort of draws the contours of almost every debate imaginable around every provision of international humanitarian law imaginable. But two that the ICRC have found to be deeply important are debates around how to define what constitutes an attack when talking about a cyber operation, and a debate dealing with what protections international humanitarian law affords civilian data. I thought that was going to happen a lot sooner. Excuse me. I'm going to grab a few. On the issue of attack, what I've failed to mention here is that the principle of distinction, the principle of proportionality, and the principle of precautions in their most robust form, both in customary international humanitarian law, but also as articulated in Additional Protocol 1, apply to and only to military operations that qualify as attacks. international humanitarian law defines attacks as violence in offense or defense against the adversary. So there is a definition. Over time, states have become very comfortable agreeing to the notion that an attack is something that causes death, injury, and physical damage. What cyber operations bring to this legal analysis, or this legal consensus, view of consensus, is that cyber operations can inflict disruptions that fall short of physical damage, but still have significant consequences on civilians and civilian populations and civilian objects. So think about shutting down all university computer networks or disabling banking systems across an entire country, both of which serve no military purpose, but are only used solely by civilians. So something gets lost, the ICRC thinks, when you take a narrow view of what constitutes an attack if it only constitutes physical damage. On the other hand, by thinking a bit more broadly, you have a larger protection surface if you talk about an attack also covering loss of functionality or the disabling of a computer system, or computer network. The ICRC is of the view, and I should say there are a number of states, well, there are a number of states that have not pronounced on this. There are a number of states that I think are still curious on what direction they want to go and giving themselves some legal latitude to determine where they're going to land in this debate. But there have been a number of states that have gone out to say either, yes, when it comes to cyber operations, for it to constitute an attack, it must cause physical damage, and a number of other states, a growing number of other states, that have said a cyber operation can constitute an attack and be regulated by distinction, proportionality, and precautions if there is damage that is not physical, that constitutes disabling a system or having it lose functionality of some degree. So that's one of the big debates that's taking place. The other is around the issue of civilian data. And here, what I can say is I usually think about this, the ICRC usually thinks about this in sort of three different ways. One is that there are specifically protected entities in international humanitarian law, and the most obvious one is medical services, the medical mission, that must be respected and protected. And the ICRC says, well, that language is pretty broad. It was intentionally broad. It was supposed to be extremely broadly protective, and therefore the data of medical missions cannot be disrupted, whether it's physically or whether it's through a cyber operation that doesn't cause physical damage. The other consideration, the second consideration, is that you can have disruption or erasure of civilian data that results in civilian death or loss of life, or potentially even physical damage. And when that happens, it constitutes an attack because of the indirect effects. And that's something that is shared not exclusively, but not exclusively, widely amongst, not exhaustively, but shared widely amongst states. Now, beyond this, you still have the possibility of civilian data that does not fit within the specifically protected entities, or that may not cause death, injury, or physical damage. And so I go back here again to things like the erasure of all of our social security information and identity information at this university, for example, or at a financial institution. And here the ICRC again says it just doesn't seem logically appropriate to say that all of the financial records that are physically stored in the bank that would constitute a civilian object, just because they're PDF and now stored in a database, somehow lose that protection. But that's where these debates stand. And I think they're debates that I've seen governments struggle with. And I think they're debates that lawyers in militaries doing operational law are probably finding themselves either needing or preparing to have to engage with more so than in a number of years. So that brings us to risks, some IHL considerations, and that leaves us with the issue of real-time patterns. I'm going to take that as an opportunity to grab a little bit of water, if I may. And then I'm going to go over to this chalkboard over here. And I'm going to talk to you a bit about, sorry, it took me, I don't know, 2 to 3 months to actually learn to pronounce this word correctly without just stumbling over it. The civilianization of cyber activities in armed conflict. And I've already used up the entire space of this chalkboard, which I was trying to save. And I'm not going to explain to you all in one sort of captivating, sort of defining sentence what this means, but I'm going to try to unpack for you the different elements and why we think it's important. Here's some space. Okay, I'm going to talk about the how, the who and how. I want to talk to you about why it's new. I want to talk to you about legal considerations the ICRC is thinking about that arises from this phenomenon. And then I want to talk to you about possible responses by government, but also by others. I'll get to a second who those others are. Okay, so what we're seeing, and this is going to resonate a lot from what's been out in the public, and this is all publicly available information. As you may know, the ICRC takes a very rigid approach to not disclosing confidential dialogues and facts that it uses to engage with bilaterally with parties to the conflict. And so you'll see me not talk about violations, alleged violations of a specific country or a specific actor or anything like that, but I will describe to you what's available in open source materials and how we're analyzing it. So what we're seeing is we're seeing individuals acting as individuals. We're seeing groups acting not super coordinated in some cases, but somewhat coordinated, common interest, common purpose, common intent. We're not talking about groups that fall under a chain of command of a military that's a party to an armed conflict. And we're also talking about private tech companies. And what are these different individuals, groups, and private tech companies been up to? So what we know is that, and I'll get to this in a moment, there is now the possibility for individuals to act in their own private capacity to do things like share intelligence information that can be useful for military operations through apps that's on your phone. I can get into more details about what's been publicly reported about this, but hopefully you can sort of get a sense. This is about things like taking photos of something, geolocating it, that information getting shared to militaries, militaries being able to act on that information. You have groups that are acting, again, not in a super coordinated fashion all the time, but collectively engaging in denial of services activities to sort of try to shut down adversarial websites and things like that. And then you have private technology companies that are providing cyber defense capabilities to adversaries in conflict. They may be providing hardware, they may be providing software, it may be generic. It may be things that they were doing before the armed conflict, and now they're still doing them in the armed conflict, but in doing them, they are still factually finding themselves supporting one side and doing things that may be found to be detrimental to the other side. And there are a number of different ways that we're seeing this happening. One is that we see it as being voluntary actions by the individuals, by the groups, by the tech companies. But we also see states or governments making, got that word wrong, sort of encouraging statements. This is sort of at the most, the highest level, nothing sort of very specific, but sort of a call to arms without much more, call to cyber arms without much more. We're also seeing what we're calling something called performative nudging. This is where a government in some way assists civilians to engage in support activities to help them out. It could be by providing specific targets of interest, but not necessarily providing them with the means or capabilities to effectuate that target of interest. It could be providing them with means of technologies, such as apps, but without telling them what exactly to do with them. But there is government involvement. There's government, we're saying, nudging. We also have issues that are more of a direct assistance. I should say, aside from performative nudging and maybe voluntary, this is my language. These aren't sort of terms of art or a lexicon that's been agreed on by anyone, the ICRC or otherwise. Performative nudging, you can Google search and you'll find some stuff that we've done on it. But direct assistance, we're talking here about a bit more cooperation, a bit more coordination between the civilian sector and governments to carry out cyber operations. And then you have either legal or other obligations being imposed, which I'm thinking about here is mostly around the private cybersecurity sector that's responsible for protecting a country's national infrastructure, critical infrastructure, and governments are starting to think more and more about what legal obligations should be placed on these cyber defense companies to provide information, threat intelligence, threat information, so that governments can get involved in defending their own networks. So then there's this sort of question about sort of what's the big deal about this? So Additional Protocol 1, drafted in the 60s, agreed upon in the 70s, sort of knew that civilians have always been participating in situations of armed conflict. There's a specific provision that says if a civilian is directly participating in hostilities, they lose that protection from being the object of direct attack. I'll get to that in a moment. So what's new? Why is the ICRC sort of raising a flag about this? And this is under legal consideration, but working with me here. Oh, there it goes. Another one broke. So what we're concerned about is that what we have is that we have cyberspace having really no geographical boundaries. We're dealing with the distribution of technology that allows civilians in very far off places and at very fast speeds to get involved in ways that they previously did not have access to. And we're also seeing, because of those two things, an expansion of the attack surface, which means not only can there be effects outside territories of armed conflict from a third party state, but also operations carried out by civilians in the territories of armed conflict can have effects on third party states abroad, getting into networks that transcend international boundaries, satellite systems, software. And so we're very concerned about what this all means and largely how states are going to respond to this phenomenon, which we think, without further consideration is one that's going to sort of expand the challenges and the problem sets. And these are the legal considerations that start to give us some heartburn, not in the sense that, oh, international humanitarian law should revisit the rule. And I should have mentioned this before. International humanitarian law does not explicitly prohibit civilians from participating in hostilities. Domestic law may, very often it does. So we aren't really saying that we need to recraft international humanitarian law to rethink that proposition that civilians should be prohibited under IHL from directly participating in hostilities. But there are some big consequences if it isn't managed well. One, I'll bring these over here, is the starting point for the ICRC is these individuals, these groups, and these private technology companies' employees, and the objects that they rely on, computer consoles, the buildings that they go to work on, their desks, their computers, are civilian. They're civilian as people, and they're civilian as objects. But there are very exceptional, narrowly tailored rules of international humanitarian law where those protections can get lost. And in a world over here, where there's a lot of debate, and we need to oversimplify thinkings around the principle of distinction, and over here, we're actually seeing these debates play out, and whether states are prepared for giving answers to what constitutes a cyber activity by a civilian for that civilian to lose their protection from being attacked, is a space that we're all getting sort of thrown into. And for persons, the way you formulate that test is, I mentioned it before, it's a three-pronged test with the temporal element to determine whether or not someone retains their protection from being attacked. They always retain their civilian status, but do they lose their protection from being attacked? That's answered by the test of whether they are directly participating in hostilities for such time as they do so. There's a temporal element that's very important. In terms of military objectives, it's certainly, I think, obvious to a lot of us that you can have civilian objects, a bridge only used by civilians, that all of a sudden is going to be used by an adversarial convoy. And the question is, does that bridge constitute a military objective? Because if you blow it up, you can disrupt the advancement of that convoy. And so there you have to look at a very rigorous definition for a military objective. And by rigorous, I mean, it means that the location, nature, purpose, or use has to make an effective contribution to military action, and its destruction, neutralization, or damage will provide a direct military advantage. That's the test that you have to go through. But that's one issue that comes along with questions of the civilianization of digital activities. Incidental harm. Sorry, I'm gonna get some exercise today. I got my steps in. The principles of proportionality and precaution presuppose, right? Baked into them, if you hadn't noticed, is that international humanitarian law does tolerate a minimum amount of civilian harm. Right? That's what proportionality is about. It says you can't do attack if the civilian's harm is excessive. It doesn't say you can't do the attack if there's any civilian harm. And precautionary measures for avoiding or minimizing civilian harm, the threshold is you have to do everything that's feasible. So if things aren't feasible and you expect civilian harm, but the civilian harm isn't excessive, international humanitarian law would not outright prohibit that attack. And what's interesting here is, of course, because of the interconnected nature of the digital environment that we're all living in today, but also that people living in situations of armed conflict are living in, you do have cloud computing services that are shared by civilians and by militaries. You have telecommunication systems that are shared by civilians and shared by militaries. And so the issue arises not only are individuals, groups, and the private tech company employees and properties all of a sudden losing their protection, but it means if they do, there's now a tolerance for incidental civilian harm to things that are in proximity or connected to or reliant on those individuals, groups, and tech companies. The other thing, and I realize I'm probably getting in a space where you can't read, so I'll just, has that been there for a while? Have you just not been, have you been able to see some of this from somewhere? Okay. So also civilians are not military trained. Tech companies are not militarily trained. Some of them are. There are a lot of former legal advisors from the military that have gone into tech companies, but a lot of them are not. So the question arises, do they even know the risks that they're taking on when they start engaging in these activities? And do they know the rules of international humanitarian law when they engage in them? That's a big question mark. This is a very new space for the ICRC to get involved in, talking to hacking groups, for example, talking to private tech companies, for example, trying to understand how they think about international humanitarian law, if those are three letters that they've ever heard of before or not. That's kind of a joke. It's kind of not. For lack of space, but it's very important, we also have the principle of distinction coming heavily under strain. You have more and more civilians acting in ways that governments or non-state armed groups may perceive or think of as directly participating in hostility or operating on specific objects that might be thought of as constituting military objectives. And so one way is to sort of say, oh, distinction is under strain. That's not great, which it's not. But there also has to be, and I'll get to them in a moment, responses to try to mitigate the potentiality for that broadening, what appears to be a broadening potential attack surface, which provides more opportunities, quote unquote, for errors to be made and incidental harm to take place. I mentioned it before, there's a geographic untethering that happens with the civilianization of cyber activities. I won't repeat that. Yes, I will. What we're seeing there is the potential for both individuals, civilians on third-party states to provide support into situations of armed conflict, and for civilians who engage in providing their support in a situation of armed conflict in the territorial confines of an armed conflict, for it to have effects by the harm migrating across international borders through cyberspace. Okay, that brings me to responses. So one is, let's disseminate international humanitarian law. Seems like an appropriate thing to do if this is happening all over the place and civilians are increasingly finding themselves providing support in situations of armed conflict, maybe not reaching levels of direct participation of hostilities. So they should know that they remain protected. On the other hand, they may want to know when they lose their protection from international humanitarian law. On top of that, states have what the ICRC regards as an obligation under customary international law to disseminate international humanitarian law. They clearly do that. States clearly do that, or think they're obliged to clearly do that when it comes to their own armed forces. There probably needs to be more work done on what states view or about sort of broad public dissemination of international humanitarian law. We also have the need for clarity on two things. Clarity on rules. I don't need to get into that because I've mentioned that over and over already. But for states to come up with whether or not they want to put the flag in the sand over clarity of roles and responsibilities. Who's going to carry out cyber activities from their jurisdiction that has consequences in situations of armed conflict? That might be more of a domestic law issue. but it's going to have bearing on everything we've been talking about. Finally, segreg. Wow. Start all over there. Segregation of services and use of segregation of those services. So what I'm talking about here is are there ways, can we imagine a different internet where everything isn't quite as jumbled up as it is already today? Can we imagine cloud computing services and information technology systems that aren't as shared in the way that they are between civilians and between militaries? Are there things we can do more than are already done? The ICRC isn't talking about creating an internet for the military or an internet for the civilians. What we're talking about is looking for opportunities to manage and mitigate the risks that we're flagging, both at the physical level. Different modems are used only for civilians, only for militaries, but also at the logical level if possible. And so we're making headway and having conversations about what the possible technical realities are around segregation. And then finally, and this is where I'll wrap up, given the role, at least in the Ukraine-Russia international armed conflicts that private technology companies have played in cyber defense and other and in the realm of outer space, are there things that they should be thinking about doing? So some things that we can imagine is that if they aren't familiar with international humanitarian law, they should do an IHL audit. Are any of their employees directly participating in hostilities, or do they retain the full protection of civilians? Same thing with their properties. Are any of them to the point where they may qualify as military objectives? They can learn from this. They can do things with this. They can make better informed decisions around what they want to do as a company that for the ICRC has potential protection value. They can also think about informing their employees, whether their employees may be directly participating in hostilities or whether they may be working on properties that constitute military objectives. They may think about doing that for their customers as well. And then finally, I think private companies also have the potential to offer a lot of innovative ideas and be entry points for conversations around how these private systems, these private technologies that are not frequently owned, operated, run, managed by governments, but instead by private technology companies, critical infrastructure, information technology systems, whether they are capable of entering into this question of doing segregation in a meaningful way, in a useful way, not in an overblown way of sort of saying there's one internet for the military, one internet for the civilian population, but something more refined, something more strategic, something more possible. So for myself, for the International Committee of the Red Cross, this represents some of our most up-to-date current thinking on applying the principle of distinction to cyberspace, specifically as it relates to what we're calling the civilianization of cyber activities and armed conflict. I'm very grateful for the opportunity to share it with all of you. The last thing I'll say is that I think this is a really unique portrait of what it looks like to think about what international humanitarian law is intended to do on the ground for people it tries to serve, victims of armed conflict. What the sort of high fidelity rules are, that each word has a meaning, has a history, and then seeing how all of that is actually playing out on the ground and how you can think about international humanitarian law as a sort of protective legal framework for civilians that are caught up in situations of armed conflict. And so I will end it there, and thank you for your unwavering patience and time.
Thank you very much. The thoughts, all that. So I really like the introduction of moving from kinetic operation into cyber and actually asking the question, does IHL apply, given an explanation, and then yes, and then how it applies, and linking it with the legal framework, the full scope of IHL and the principle, and focusing on principle of distinction, and that issue of blurring the line between civilian and combatant is the main issue that needs to be addressed, but it's framed within a legal framework that the actually parties of armed conflict need to abide to. I like that you quoted the ICJ 1996 nuclear. That's nice. It's a law class. Yeah. And also opening to the fact that there are debates. This is something that's in flux, something that's dynamic, and the humanitarian actors, government are all aware of that. And I think remaining size of the issue and kind of having discussion is part of success. That's what success looked like. So I want to bring your attention, because sometimes as students, there are unilateral government statements. There's a legal expert group. So with the talent manual, so there are things happening. The contribution to the open-ended working group and the 4, 6, 7 pager fact sheet. Yeah, I know our colleagues. It's going to be 10-page long. That's what it's going to be. So there are some documents that are soft law and evolution, but that's part of IHL. If you want IHL to be relevant, it needs to be flexible enough to apply in the situation of armed conflict, but it needs to be rigid enough to actually mobilize the state and be a language, kind of a common language for all the states. So providing that background was definitely useful, Jonathan. Thank you very much for that. I have a few questions on my own, but I want to allow the participant to actually ask their question. So I'll be dynamic myself. I'll be walking around with the mic so the people that online can hear your question. I'm talking right now, so you can think of your question and then raise your hands. That's what I'm doing. So anybody, I'm looking for, hey, and you can come on the side, or I can come and meet you, or I can ask my tough questions. No questions? Yes. Thank you, Shelby, for breaking the ice.
So kind of plays a little bit into distinction. And when looking at distinction, how far do individuals, groups, or doing this IHL audit, would you have to look into the incidental harm or second, third effects that doing these attacks would have? Like, what is the kind of understanding and opinions that have been put out?
Yeah, thank you for that. So the principle of distinction is answering the question of whether you can attack something or someone or not. And if the answer is yes to that, through those different tests that we talked about, combatant, military objective, direct participation in hostilities, then you need to do a inquiry into whether or not there will be any incidental civilian harm. And for international humanitarian law, incidental civilian harm is really categories of civilian death, civilian injury, and damage to civilian objects. And the ICRC's view, which is shared by a number of states, but not all, is that incidental harm includes both direct and indirect, right? So direct harm is you blow up a military building and civilians are walking by and they are directly killed and or injured by that attack. As far as I know, every state agrees to that. Indirect harm goes, I think, to where your question lies. The second, third order effects. For the ICRC, we've looked back at the drafting history, and our view is that incidental harm has no geographic or temporal limitations on it. The limitation it has on it is it's what's reasonably foreseeable by the commander. Yeah. And so this is in contrast to language that you can see in at least one law of war manual that says incidental harm should be thought of primarily as that which is direct and immediate. That stands in contrast to the ICRC's view that incidental harm includes direct and indirect harm, which is reasonably foreseeable. And so that would apply the same to cyber operations. And my understanding is that there are a number of countries who spend considerable time trying to find out what happens when they carry out certain activities on an adversary's network because of this issue in particular, the interconnectedness of sort of military things and civilian things, and you not wanting the effects to escape the intent of the commander's operation.
Very much for your answer. Any other questions? Hi, Jonathan. I was wondering if you could tell us a little bit more about the whole notion of the untethering. As a lawyer, we always like to look for scope of applications. You were talking about geographic and temporal scope, and realizing that it has to land somewhere with the whole notion of the untethering. You know, how do we get to a point of certainty when we're looking either for attribution or we're looking for in our IHL audits, you know, where does responsibility, repercussions, implications land? Thanks.
So, thank you. So the the former deputy staff judge advocate U.S. Cyber Command is going to be at this very famous gathering in Tallinn called SciComm. Kurt Sanger, he's retired. He's written sort of prolific pieces and done great podcasts. He's just a nice guy. He's going to be talking on exactly this issue this week or something about this. And so I'm keen to hear what he has to say. A few considerations. One is the ICRC, again, apologies. The ICRC is of the view, for example, that if you have incidental harm for an attack that takes place in the territory of two parties to an international armed conflict, but the incidental harm occurs in a third country, that incidental harm is part of your proportionality assessment and your precautionary measures considerations. I think where things get really difficult, both from a political and from a legal area, and particularly difficult from an ICRC legal area, because we only deal with international humanitarian law, and this stuff starts to open the cracks into questions of other international legal frameworks. Jus ad bellum issues in particular, is what happens, and we've seen this. So happy to have a chocolate. Okay. What happens when you have a conflict between two states and you have data centers that have military information on them that can constitute a military objective, and a private tech company moves that data center to a third country that's not a party to the armed conflict? If anyone can provide me an absolute clear answer to that question, write a paper on it, write an article about it, think about it, talk to your professors about it. There's a lot of legal action around a whole mess of different legal considerations that go into that space. So that's one thing. And then the other, just to mention whatever I've been sort of saying, is what happens when you have third-party nationals starting to make efforts. There are going to be questions around neutrality potentially. There are There are going to be questions potentially around domestic law. Does the state want their own citizens? A lot of states say, no, your nationals, your citizens cannot, without the government's approval, start getting messed up in another country's armed conflict because it creates foreign affairs nightmares of epic proportions. But these are the types of things that I don't think that the ICRC can honestly sort of flag the problem of civilianization without flagging these issues, even though they may not be sort of tried and true traditional IHL framework issues.
If you with the audience.
Yes.
So at the beginning of the war, Ukraine-Russia war, there was this huge video that went viral from Anonymous, like the hacker group. I just wanted, like, that was kind of like a first real look from the population on cyberspace, like threats, or I'm not sure that constitutes an attack, but I just want to know like what your thoughts are and how this applies in all of this stuff.
So without getting into any specific context, as I tried to sort of insulate myself from the ICRC, I can't do that. But you're probably talking about a group that I guess is acting from here, a non-territory that's not party to an armed conflict. I'm making an assumption, and having an effect in a territory where there is an armed conflict going on. So it's just to say, I mean, that is exactly the type of case study, for lack of a better term. It's a real life situation where real lives are being affected, but that's a scenario that raises a lot of what it is that's being talked about. And then depending on what the actual effects are, there's interesting legal questions around, can someone who's not in a territory of a party to an armed conflict even DPH, or do you call it something different? I don't know the answer to that question. I'll have to check to see if my ICRC colleagues know the answer to that question.
Thank you for the question. Yep, I'm coming with the mic. Sit down.
So this maybe is not IHL per se, but going back to the idea of third parties affecting a conflict, an international conflict, or non-international, it doesn't matter really. But to what extent could one state then expect that third state to do something about that?
So this is where I'll be absolutely honest and say that exceeds my legal bandwidth as an IHL legal advisor of the ICRC. The problem with that answer to you is that that doesn't exceed the legal bandwidth of legal advisors to militaries and governments around the world. I have to answer.
So is that more of a question of ad bellum then, than
that gets into questions that are happening, and they're in the pages of the Talon manual around obligations of due diligence, I think, around obligations of neutrality and what states have to do to protect their neutrality, even when activities are being engaged in by civilians. I see a few people in the audience that I know would have ideas, and I'm trying not to make eye contact with them right now, so I don't look bad when the eloquent answer is given. But that's what I would say as a ICRC legal advisor. That's a bit out of my bailiwick, but it's an absolutely relevant question.
kudos to not saying anything?
I'd love to pile in. Okay. So I'll give us here. So Lieutenant Colonel Daria Eastlake from the Office of the JAG. So I'm a military lawyer for Canada. I guess I would put a steer in noticing what Jonathan's saying. There's tons being written right now by different academic writers on neutrality law, qualified neutrality. There's a big debate even just about what is neutrality. So one area to look at. State responsibility. What would Canada as a state or any of these other states have to be responsible for what its citizens do or what we don't do? So that kind of gets you into this complex area. What are use ad bellum issues? What rises to a level of a use of force? Looking at the UN Charter and Article 51 and customary international laws, prohibition on use of force or threat of use of force by a state to another state. So there's tons of issues coming up. And unfortunately, I would just say that the conflict going on right now in Ukraine is bringing a lot of these issues to bear. But yeah, there's certainly a lot of topics that you can go down, and as a law school or any students out here, definitely looking at these ideas of what people are doing and where are they from and why are they doing them and who do they speak to.
Brings up the question too of multinationals, right, that are providing internet services, for example. I've already stated whatever. Say, go ahead.
No, thank you for the question. Thank you for the contribution. I think I think one lesson is IHL does not answer all the legal questions that arise under international law when it comes to cyber operations, whether they're being carried out by civilians or by military actors. Victims of armed conflict.
Yeah, so I have like a pretty long question, but it's based on what we've seen today and in the last day's conferences. So I was wondering, how can the ICR deal with qualifying war prisoners, for example, or attack even civilians that are involved in cyber warfare, considering that prisoners have to openly wear a uniform, or that anonymous attacks can be launched on the dark web or even like on VPNs, and that given the fact that in IHL, it is forbidden to attack civilians that are not involved anymore in warfare, because like there's this whole aspect of attacking on, for example, the dark web and disappearing. So how can we actually deal with these kind of situations?
So I think there are a number of things that you're getting at. One, I think, is there the unique features of attribution in the cyber environment, or the difficulty around attribution. If I repeat your words, sort of people disappearing after they carry out certain activities. I don't, as a factual matter, suspect that that's going to go anywhere anytime soon. I will say that I think we've seen a shift where questions of attribution remain difficult, but there have been different techniques and methods and approaches to attribution that have made it not a non-existent problem by any means, but one that's been solved in certain cases and been solvable in the past. And you also see states increasingly being willing to make statements of public statements of attribution. A lot of what you're talking about might also end up falling into sort of domestic criminal law frameworks and considerations, depending on the context. I'm not exactly sure with what you had in mind. On the question of sort of applying the principle of distinction through wearing uniforms, I think there's a legal memo from the 1980s or 90s from the United States where it says I'm really paraphrasing here, but basically military cyber operations must be carried out by uniformed US military personnel. There are some views that say you need to wear uniforms during an attack, during a military operation, excuse me. That rule should be precluded from cyber operations because of the unique nature of them happening at a distance from where the effects are, or even where the enemy might be able to reach them. Myself and one other person wrote a piece sort of trying to dismantle that, saying that no, the wearing of the uniform is important to effectuate the principle of distinction, even when it comes to military cyber operations. Certainly there have been instances where you've had adversaries, maybe not in situations of armed conflict, hack into web cameras and they're able to see whether someone is wearing a civilian uniform or wearing a military uniform. And there are other forms of surveillance where, you know, if military cyber operators were wearing civilian uniforms and they're sort of walking into a civilian building carrying out military activity, there's certainly surveillance means that would look at them and think, oh my goodness, this is just a civilian. They must be being attacked. So I think there is some complications around the view that the age-old requirement of wearing a uniform during a military operation should sort of be put in the dustbin when it comes to cyber operations. I don't think that's a complete answer to your question, but hopefully it gives us something to think about.
I think this speaks volume about the debate that you mentioned. Yes, IHL will apply, how it applies, attack civilian data, but also all of the basic notion that we get from the 49 convention and the 77 protocol. I've seen there was a hand up over. Yes, I'm coming over.
Hi, thank you for your presentation. I'm glad to know there's a discussion on cyberspace and AI happening, especially since that's also taking place in the international human law context as well. My question, you mentioned geolocating, and my question is in reference to open source intelligence networks that are becoming more and more prevalent on platforms like Twitter and Discord. I'm curious as to whether or not you have an opinion as to whether or not that these sorts of activities would fall under a DPH context, especially since this information is being used by both, especially like now with the hostilities in Ukraine. This information is being used by both Ukrainian military and the Russian military. And as these sorts of social media companies become more and more prevalent, this information gets more, spread out, and these communities become more and more organized and entrenched. Thank you.
Thanks. That's a great question, because if we didn't have enough problems already, we can look to the future and see the sort of the way that the scope and scale of these technology evolves and gets paired together can raise additional complications. So what I would say is it needs to be put through the grinders of the direct participation and hostility test, right? And it's a three-part test. And I think I mentioned it with a temporal element to it. The first is that the civilians' activity has to reach a certain threshold of harm, which is death, injury to civilians, or damage to civilian objects, or adversely affect the opposing military. So that's, I'm just going to put it down. Sorry for not spelling it out. That's the harm threshold. So you have to think about whether or not that's happening in the example that you're thinking of or that you're foreseeing. The next is not my nation's capital of Washington, D.C., but direct causation. There needs to be a direct link between the activity of the civilian and the harm being caused. The ICRC says that there has to be one causal step. It gets a little more complicated when it's sort of sort of collection of actors, but the act still has to be an integral part of that coordinated effort to cause the harm. And these are cumulative tests. So if it does the first and does the second, we move on to the third. And that's the belligerent nexus test. And this is a really interesting one that I think needs to be paid a lot of attention to when it comes to cyber operations or cyber activities, excuse me, being carried out by civilians. The belligerent nexus test says the harm that's directly caused by the civilian has to be designed to support one side of the conflict and be detrimental to the other side. Now, what's interesting here, and states generally agree to this three-part test, and then when you get into the interpretations, things start to get a little heated. What is interesting here, and I don't know if states have made strong pronouncements on this or not, is that there are two things to think about in the cyber environment where the belligerent nexus is not met, that are accounted for in the DPH test, and specifically in the ICRC's guidance on direct participation of hostility, which is where a lot of these formulations are coming from. They can vary from government to government and military manual to military manual. One is that if the person, my best penmanship yet, if the person is totally unaware that their activity is supporting one side of the conflict and is to the detriment of the other, they are not meeting the belligerent nexus test. Now, this is really important in cyber environment for reasons that I think are pretty obvious to us all, especially if you think about a tech company that's carrying out cyber defense operations, but they don't really know against who, for example. The other is when an individual is acting, when a civilian is acting in self-defense of them or others protected under international humanitarian law, that also is an act that, even if it is an act that directly causes military, an adverse effect on the military, if it's in self-defense, that does not meet the third belligerent nexus test, and therefore does not meet the direct participation in hostilities test. So I have not answered your question in the slightest in relation to the specifics of artificial intelligence. But when you're talking about big data sets where people don't necessarily know what they're contributing to, you can start thinking about, oh, is there direct causal link to the harm? They don't know about it. Are they totally unaware? Or are they aware? And those are the difficult questions that are going to be answered primarily on a case-by-case basis. But I hope that gives you a framework. I'm glad you asked the question, because it's a really important expansion of what I had been talking about how people either retain, how civilians either retain or lose their protection from attack under international humanitarian law.
Thank you. We have time for one last question. Okay. We are tackling difficult questions, but also learning difficult words. So pronouncements and civilianization. Here we go. I messed it up. Very tough. So you need to say civilianization. So that's the trick. Civilianization. Yeah.
In the same line of thought, disinformation. I understand that like people were just like sharing something on Twitter is totally unaware, but as for the source of spreading disinformation, do you think that can be included in DPH?
I just want to make sure I heard you for disinformation or
yeah, like spread. Yeah.
We have a whole bunch of stuff that the ICRC has done on disinformation and disinformation. I don't think any of it touches on that question. So my gears are turning. So One of the big issues that the ICRC has had, so we see considerable protection concerns, meaning protections for civilians, human costs, humanitarian consequences arising out of misinformation, disinformation, hate speech. That's sort of the terminology we use. Other people use different terminology, but it's a type of information that can escalate conflict. It can escalate communal tensions. It can escalate discrimination. It can escalate marginalization. It can make people's lives worse. And in a situation of armed conflict, that's not necessarily that hard to do. So people are very vulnerable to those types of misinformation, disinformation, hate speech consequences. It can be very difficult to figure out direct causation between someone who put something out and what the actual harm is. That could be caused to a military adversary, or for that matter, resulting in death, injury to civilians, or damage to civilian objects. But there are other ways or additional ways to think about how international humanitarian law treats misinformation and disinformation. One way that we've started to sort of unpack a little more publicly is that misinformation, disinformation, depending on how you define them, can in and of themselves constitute violations of international humanitarian law. So, for example, there's a prohibition on prohibition on threats of violence that terrorize civilian populations. It's very easy to do online. Child recruitment is prohibited under international humanitarian law. Very easy to do online. You can have perfidious acts. A little more difficult to do online because it's a tough test. If you ever get familiar with it, gives me a headache, but it's potential. We've done the homework and figured out it's possible. Issuance of flagrantly, the word to the bucket, flagrantly unlawful orders can be done online. That may not even be misinformation or disinformation, by the way. So I think it's also important to think about what that intersection can be there, separate from what I think is a really good question, which gets answered by, once again, do you know what the harm is from the misinformation? Is there a direct causal link between the person who put the information that caused the harm, and was it to support one party to an armed conflict and be to the detriment of the other? That's how I would think about that question.
One thing that you mentioned in your responses to this civilian thing that we're trying to avoid was training civilian population in IHL, doing IHL audit. And as I was drafting a few notes, I'm like, well, that's in action. That's what you're doing right now. We might not have IHL lawyers in everyone, but some people might join tech companies. They might do other type of work. And then this training in IHL will be part. We hope that they hear our voice or funny comments in the back of their head if they're doing anything that's remotely affecting civilian in armed conflict. So for that, I really want to thank you for contributing with your presentation and also with your handwriting, your penmanship. Very, very impressive. I'm a left-handed, so that would have all been smudged. So very, very impressive. And without further ado, I'll leave Professor Jaber Fatali for closing remarks, but thank you very much, Jonathan.
Thank you, thank you, Jonathan. Many questions to ask, many rivers to cross, and many answers has to come. Thank you very much. So, just I will say a few words. So, good afternoon, each and every one of you, for attending this summer school on behalf of our center as interim director of the Human Rights Research and Education Center. I would like to say that we are very pleased and delighted to have you, to be able to welcome you all, students, professor, practitioner, professional lawyers, and to host this event, the 15th edition of our International Humanitarian Law Summer School. today we are not only celebrating the 5th edition of the summer school, but we are celebrating the crystal anniversary of the partnership between the Canadian Red Cross and the Human Rights Research and Education Center. So thank you, Sophie, Fanny, and all the members of the Canadian Red Cross for your hard work and commitment to strengthen this amazing and fruitful partnership and to organize this summer school. I extend my thanks to our guests, speakers, and lecturers who generously accepted to share with all of us their knowledge and expertise on various aspects of international humanitarian law. Your teaching is very important. In a world of uncertainty and warmongers, we need your teaching. We need international humanitarian law more than ever. Today, Professor Jonathan Horowitz's presentation is a proof if needed. So let me thank you once again for your dedication and effort. A special thanks to my colleague, John Packer, who's on leave, our director assistant, Viviana Fernandez, and our communication officer, Caroline Fouché, who have been working since many years to ensure that the center becomes a world reference and the destination of choice for scholar, researcher, students, and practitioners in the field of international law in general. I would like to add my voice to Sophie to remind you that the University of Ottawa is located on the unceded and surrendered territory of the Anishinaabe Algonquin Nation, whose presence here reaches back in time immemorial. Chers collègues, chers participants, je veux vous remercier pour votre participation à cette école d'été, la 15e édition de l'école d'été du droit international humanitaire. C'est tout un plaisir de vous accueillir, de vous voir être impliqués dans cette école d'été. Nous faisons de notre mieux dans ce monde marqué par tout ce que vous savez, de turbulences, de guerre et du discours, de belligérance ici et là, donc dans un temps où la notion de recours à l'arme nucléaire est devenue à certains égards banalisée, nous avons besoin de voix de sagesse. Ces voix de sagesse proviennent des gens qui travaillent dans le domaine du droit international humanitaire. Nous faisons notre part ici au centre pour promouvoir, pour divulguer l'information et pour inviter les chercheurs, les étudiants, les praticiens pour partager avec nous leurs soucis, mais aussi leurs réflexions sur les questions qui intéressent la communauté internationale. C'est tout un plaisir aujourd'hui de célébrer cette 15e édition de l'école d'été du droit international humanitaire, mais aussi c'est l'anniversaire cristal d'un partenariat fructueux avec la Croix-Rouge canadienne. Je veux remercier les membres de la Croix-Rouge canadienne, les membres du centre, de notre centre ici, aux droits de la personne, notre directeur assistante, Viviana Fernandez, Caroline Fouché, notre agente de communication, et tous ceux et celles qui ont participé à l'organisation de cet événement. Je vous invite, bien évidemment, c'est la fin, ou pour moi, à certains égards, parce que je suis intérimaire, j'aimerais bien vous inviter à une petite cérémonie qui va avoir lieu ici au 3e étage pour partager un morceau de gâteau avec nous tous. Donc, it's the cupcake time. So please share it and welcome again.